The committee will come to order. Sorry for the tardy start. I had some votes in Commerce Committee and came over as fast as I could. But I certainly would like to thank our witnesses for joining us today to help examine the Senate confirmation process for presidential appointees and evaluate potential reforms that could help streamline the process and address vacancies and extended confirmation delays to strengthen leadership at our federal agencies. Every administration deserves to choose qualified leaders to helm critical agencies and to help effectively govern our nation. And providing a swift confirmation process without excessive bureaucratic roadblocks for these nominees is key to not only exercising the Senate's responsibility to advise and to consent, but also ensuring presidential appointees will be accountable to Congress and to the American people. In recent administrations, we've seen firsthand how vacancies at top federal positions, in many cases caused by prolonged confirmation process, have compounded significant challenges the federal government must tackle. For example, there are currently more than 180 Biden administration nominees being considered by this body. Many of these very qualified individuals could be helping to address the problems that Americans face, from the COVID-19 pandemic to significant threats to our national security. Instead, they're still waiting on this body to act before they can start their important work. The Constitution grants the Senate with an essential check on executive power, the authority to provide advice and consent on many presidential appointments. But the number of appointments and the increasingly arduous process to nominate and to confirm appointees has become burdensome and far, far beyond what the framers envisioned. Recent reports estimate that the Senate has taken an average of 103 days to confirm President Biden's nominees, and the average confirmation process took about twice as long for the two previous administrations. Not only do these extended timelines delay getting qualified leaders into vital positions, but protracted vacancies also limit Congress's ability to conduct effective oversight. Today's hearing is an important opportunity for this committee to discuss potential reforms that will help address these concerns. This is not the first time the Senate has considered this issue. 10 years ago, the committee helped pass into law the bipartisan Presidential Appointment Efficiency and Streamlining Act of 2011, which reduced the number of positions requiring Senate confirmation and established working groups that provided additional recommendations on how to make the presidential appointment process more efficient, including by streamlining the paperwork and the background check process for nominees. And while this bipartisan bill was an important step forward, since it was signed into law, even more Senate-confirmed positions have been created, and many recommendations from the working group have not yet been implemented. This has contributed to an increasingly complex confirmation process for nominees that can eat into valuable time the Senate could be voting to important legislative efforts and limiting an administration's capacity to implement a policy agenda. In addition to improving the government's efficiency and effectiveness, federal vacancy experts and good government groups have argued that additional reforms, including reducing the number of Senate-confirmed positions, can also save taxpayer dollars. The Congressional Budget Office estimated those savings could be as much as $82 million. Today, I'm pleased to welcome a group of experts who can provide unique perspectives on how we can reform the presidential appointment process, address the growing number of federal vacancies, and incentivize every administration to quickly submit nominees. I am hopeful that on a nonpartisan basis, we can examine the facts and ensure that our federal government is able to better serve the American people for generations to come. Now I'll turn over to Ranking Member Portman for his opening comments.
Thank you, Mr. Chairman. I'm glad we're having this hearing. I've had a chance to visit with the witnesses before us today, and we look forward to having others virtually. We spend a lot of time on vetting executive nominees, and it's an important part of our constitutional duty. So we should. This committee in particular sees a lot of nominees. The process can be long and difficult. I understand that. I went through 2 confirmations myself. But there's a reason for that. We want to make sure the nominees are well qualified and well qualified to serve the American people. Just in the past year, we've seen a number of troubling issues with nominees. Now, let me give you a few examples. The Comptroller of OMB's Office of Federal Financial Management is required by statute to have a, quote, demonstrated ability and practical experience in accounting, financial management, and financial systems, and extensive practical experience in financial management in large governmental or business entities, end quote. You know, there's a reason Congress put those criteria in place in statute, but the President's nominee for the position was unable to explain, in my view and in the view of others on the Republican side of the dais here, how she met those qualifications or express a basic understanding of public accounting and financing. And her nomination passed out of the committee, but it did so on a party-line vote and has yet to come before the Senate. We also have received distressing allegations regarding the conduct of nominees to serve on the Federal Labor Relations Authority. We've asked the Inspector General to look into these allegations, so I don't want to prejudge the issue, but they're very serious allegations and a significant concern to me and many of my colleagues, and yet those nominees were on their way to this committee before we insisted that we give the Inspector General a chance to look into it. Finally, multiple nominees for positions such as the recent nominee to the Merit Systems Protection Board, which is intended to serve federal workers of all political persuasions, and in fact has a role to play there to be totally nonpartisan. Anyway, some of these nominees have tweeted extremely partisan statements. These statements have included, by the way, insults and partisan attacks against members of this committee and also fellow members of the Senate, our colleagues, at a time when we should be trying our best to return to saner times when both parties can work together in a bipartisan fashion to serve all Americans. So my point is, I guess, it's also about the quality of the nominees. It's hard to imagine these nominees being put forward, by the way, if we still had a 60-vote threshold to end debate on a nomination. When the President's party has control of the Senate and a nominee only needs a simple majority to be confirmed, the majority party tends to overlook serious concerns sometimes with these nominees' qualifications, in my view. And that might otherwise not be true if bipartisan support were necessary. Maybe that's what's been happening recently. Maybe that explains it entirely. I don't know, but this concern applies to both parties, by the way. Same was true during the previous administration with some nominees. One can argue that this weakens congressional oversight because nominees who don't have to get support from senators of the other party might think, even if wrongly, that they don't need to be responsive to those senators' concerns once they're confirmed. And obviously, we've seen some of that in this committee where we've asked for information we've not been able to receive on both sides of the aisle. We probably can't turn the clock back. We are where we are. But I do think we need to continue to take our advice and consent rule seriously. I understand some of our witnesses are going to propose reducing the number of Senate-confirmed positions and explore some ways to make the process more efficient so we can attract the best people to government. By the way, Chairman talked earlier about the arduous process. Let's be honest, the arduous process includes the lengthy and sometimes bureaucratic pre-confirmation process at the executive branch as well. Anyway, I believe some of these reforms, including reducing the number of Senate-confirmed positions, have merit and could work if carefully crafted. I'm also glad that the witnesses will discuss the importance of having confirmed inspectors general. Chairman Peters and I have led members of this committee from both parties in sending letters to President Trump and now President Biden that urged them to nominate IGs expeditiously and offered the committee's assistance in identifying qualified candidates. But again, I just want to say at the outset that no matter what reforms we discuss, nominees need to be qualified. And it's our role to vet these nominees. And we have to encourage the executive branch to send us nominees that do not have some of the concerns that I raised earlier. And the confirmation process needs to be thorough and nonpartisan or bipartisan at least. So I thank the witnesses for testifying. I look forward to hearing what they have to say about these issues, and we look forward to engaging in a dialogue on them. Thank you, Mr. Chairman.
Thank you, Ranking Member Portman. It's the practice of the Homeland Security and Government Affairs Committee to swear in witnesses. So if our witnesses would please stand and raise your right hand, including our witness who is joining us virtually. Do you swear the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God. All have answered affirmatively. You may sit down. Our first witness is Ann O'Connell. Ms. O'Connell is the Adelbert H. Sweet Professor of Law at Stanford Law School. She is also a contributor to the Center on Regulation and Markets at the Brookings Institution and an appointed senior fellow of the Administrative Conference of the United States. Most recently, her work has focused on acting officials and delegations of authority in federal agencies, the loyalty and competence of agency appointees, and inspectors general. Her research and teaching also focuses on administrative and constitutional law. Ms. O'Connell, welcome to the committee, and you may proceed with your opening comments.
Thank you. Chairman Peters, Ranking Member Portman, and members of the committee, thank you for the opportunity to participate in today's important hearing. I'd like to make 3 points. First, the current appointments process for filling key federal agency jobs is broken at the White House and in the Senate. Second, vacancies in federal agency leadership, particularly if frequent and lengthy, have detrimental consequences for our government. And third, nonpartisan reforms that preserve the political branch's constitutional roles are possible. First, there are vast gaps in confirmed agency leadership up and down the organization charts. Those gaps result from lags in nomination and delays in confirmation. A note, all of my figures I'll mention exclude Article 3 judicial nominations, but include all agency picks. The last 3 completed administrations, George W. Bush, Obama, Trump, did not submit a single nomination in their first 2 years for on average nearly 30% of vacant agency positions. At the end of December, compared to the past 4 administrations, President Biden had submitted fewer agency nominations than all of his predecessors except for President Trump. Official nominations are just the start of the appointments process. At the end of December, the Senate had approved fewer agency nominees under President Biden than Presidents Obama, Bush, and Clinton. President Biden just beat out President Trump in absolute numbers, but in percentage terms of submitted nominations, President Biden fell last. Just 53% of his agency picks were confirmed. At the 13-month mark of the Biden presidency, so through February 19th, the Senate had confirmed 370 agency nominees, 65% by voice vote, 35% by recorded vote, and not a single one by unanimous consent. At the same point in President Trump's term, the Senate had confirmed 348 agency nominations, 76% by voice vote, 24% by recorded vote. For Obama, the Senate had confirmed 100 more nominees than President Biden by the close of month 13, 488. 95% were by voice vote and only 5% by recorded vote. President Clinton was the last president to have agency nominees confirmed by unanimous consent in his first year. Second, vacancies undermine agency performance. The MSPB has been practically unable to function since 2017 when it lost its quorum. The Senate did confirm 2 of the 3 pending nominees on Tuesday. Its backlog currently stands at around 3,600 cases. Vacancies also foster confusion and lower morale among non-political employees and undermine both agency legitimacy and constitutional safeguards. These delays also deter potential nominees from pursuing government service at the highest level. In many agencies, acting officials and delegations of authority do help to fill the gaps, but not without exacting costs of their own. Even though acting leaders have the same formal authority as confirmed leaders, they are less able to wield it. They get less buy-in from the employees who work beneath them, relevant congressional committees such as yours, and the public. In addition, decisions made by acting leaders may face increased legal risks. I should note that some delay is necessary, even good. It takes time to find compelling, qualified, and diverse leaders and to properly vet them. Third, the process could be improved while respecting the political branch's constitutional roles. I focus here on 3 proposals. 1, decrease the number of Senate confirmed positions. 2, streamline the vetting of nominees. And 3, incentivize quicker nominations from the White House as part of changes to the Federal Vacancies Reform Act of 1998. The most significant action Congress could take to improve vacancies is to cut the number of Senate confirmed jobs. The easiest place to cut is likely for part-time positions. They could be moved into cabinet departments where the secretary would pick members without Senate involvement to meet any appointment clause concerns. The next place to look would be positions that have not received nominees in the first half of a presidential administration in both recent Democratic and Republican presidencies. The Partnership for Public Service, who you will also hear from today, has additional compelling proposals. If the goal is to decrease vacancies, it might be better to permit agency heads to select leaders, at least for some jobs, instead of the president alone, as was done in the 2012 cuts. More choosers, less time. Second, the Senate and the White House should commit to revisiting the recommendations of the Working Group on Streamlining Paperwork for Executive Nominations, most of which have not been implemented, which was established by the 2012 Act. Finally, I support the Accountability for Acting Officials Act. It would nearly halve the permitted time limits for acting officials outside of pending nominations in the most important agency positions. It would also restrict acting inspectors general to senior staff in IG offices. I would actually go beyond the Accountability for Acting Officials Act and expand that to cover other confirmed IGs. And it would resolve ambiguities in the Vacancies Act that generated litigation in the Trump administration. There is one reform with regard to acting officials and delegations of authority that is more expansive of presidential power, and that would be that I would also allow more nominees, those who have been confirmed to another post, to serve in an acting capacity while their nominations are pending. In 2017, the Supreme Court interpreted the Vacancies Act narrowly to allow a nominee to simultaneously serve as the acting official only if she had been confirmed to the first assistant position or had been in the first assistant position for a particular length of time. So Mark Esper in the last administration had to relinquish his acting title when the Senate formally received his nomination for Secretary of Defense in 2019, which contributed to yet another acting Secretary of Defense and to the Senate expediting its process. I look forward to your questions, and thank you very much for this opportunity.
Well, thank you, Ms. O'Connell, for your statement. Our next witness is Christine Simmons. Ms. Simmons serves as the Vice President of Government Affairs at the Partnership for Public Service, a nonpartisan, nonprofit organization whose mission is to build a better democracy and a stronger government, including programming that specializes in presidential transitions and in improving Congress. Prior to her time at the Partnership, she served in the administration of President George W. Bush as a special assistant to the President for domestic policy and advised the President and the White House senior staff on issues pertaining to government operations, reform, and management. She was also the staff director of the U.S. Senate Government Affairs Committee Subcommittee on Oversight of Government Management. Ms. Simmons, welcome to the committee. You may proceed with your opening comments.
Thank you very much, Chairman Peters, Senator Portman, members of the committee. Appreciate the opportunity to be here with you this morning. We also thank the committee for your bipartisan commitment to making our government work better and for holding today's hearing on ways to improve the Senate confirmation process and ensure that our government has qualified and accountable leaders in place. My comments today are specific to the appointment and confirmation of positions in the executive branch and rooted in deep respect for the Senate's constitutional duty to advise and consent on executive nominations. A new president must make 4,000 political appointments, and about 1,200 of those are subject to Senate confirmation. Our data show that by almost any measure, the appointments and confirmation process is in dire need of improvement. As the process is operating today, everyone loses. Numerous data points show that for each recent president has found the confirmation process harder and longer than it was for his predecessor. The average time to confirm a nominee has nearly tripled since the Reagan administration. And the Senate confirmation rate of nominees in a president's first year, when volume is highest, has dropped precipitously over the past 4 administrations. Widespread and long-term vacancies harm agency effectiveness, and that's not good for government or the people it serves. Many Senate-confirmed positions have been vacant for years across multiple administrations. According to Vanderbilt University's David Lewis and Mark Richardson, in the first 2 years of the Bush, Obama, and Trump administrations, 30% of Senate-confirmed positions never received a nomination. The lengthy and arduous confirmation process can further discourage qualified people from joining public service. Serving the American people in a presidential appointment is a privilege, and it is appropriate that individuals nominated for important positions are subject to the Senate's review. However, the confirmation process exacts a toll on nominees and sometimes on their families. Nominees subject their lives and families to public scrutiny. Many leave jobs to avoid even the appearance of a conflict of interest, hire lawyers and accountants to ensure their paperwork is free from error, sell assets and take other steps to mitigate financial conflicts, and make plans to move their homes and families at personal expense with no clear indication of when the Senate will consent to or even consider their nomination. The high number of positions subject to Senate confirmation actually decreases the Senate's control when so many are vacant, and considering them takes valuable time that the Senate could be spending on oversight, legislation, constituent service, confirmation of other more senior or more important positions, and other pressing needs of the American people. Between 1960 and 2016, the number of Senate-confirmed positions increased by nearly 60%, and in the last 11 years alone, roughly 60 new Senate-confirmed positions have been created. Along with more positions, the burden of considering them is growing. The number of nominations returned at the end of a president's first year under Senate Rule 31 has increased for each recent president, meaning nominations must be resubmitted and much of the process gets repeated. The number of cloture motions on executive branch nominations has risen in each of the past 5 administrations, meaning more floor time spent on confirmations and less time for other Senate business. So what can the Senate do about this? We have 5 recommendations. First, reduce the number of positions subject to confirmation. 1,200 positions are more than the Senate can reasonably process given your other important responsibilities. This committee led the way 10 years ago in reducing the number of Senate-confirmed positions by 163 and can do so again. Second, consider changes to the Senate's privileged nominations calendar, Senate Rule 31 on return nominations, and other Senate processes. Nominations on the privilege calendar take longer now than they did before the privilege calendar was created. Expand the holdover norm and consider adopting fixed terms for Senate-confirmed positions, for example, the VA's Undersecretary for Health, that require unique expertise and have become difficult to fill. Fourth, implement the recommendations of the Working Group on Streamlining Paperwork for Executive Nominations. The recommendation for a smart form, for example, would make the process more efficient and ease the burden for nominees. And finally, we encourage you to revisit the Federal Vacancies Reform Act and modernize the Plum Book. Greater transparency would improve congressional oversight and agency accountability, and Senator Carper has introduced, along with Senators Braun and Merkley, the Plum Act, and we applaud him for doing so. Thank you, and I am happy to answer your questions.
Well, thank you, Ms. Simmons. Our final witness is Adam White. Mr. White is a senior fellow at the American Enterprise Institute and co-executive director of George Mason University C. Boyden Gray Center for the Study of Administrative State. He serves on the Administrative Conference of the United States, and he is vice chair of the American Bar Association section on administrative law and regulatory practice. Last year, President Biden appointed Mr. White to the Presidential Commission on the Supreme Court of the United States. And after graduating from the University of Iowa and Harvard Law School, he clerked for Judge David Sentel on the U.S. Court of Appeals for the D.C. Circuit. Mr. White, welcome to the committee. You may proceed with your opening comments.
Thank you very much. Thank you, Chairman Peters, Ranking Member Portman, and members of the committee. I generally agree with much of the diagnosis that's been offered so far. Too many offices require Senate confirmation. There are too many vacancies for too long, and too many acting officers serving in offices that should require or currently require Senate confirmation. But I think the implications run further. The fixes are more difficult because the underlying causes of this problem run much deeper. So let me begin with constitutional underpinnings of the Senate's role. Needless to say, the executive branch is primarily responsible for administration, but the Senate is crucial in foreign affairs and also in domestic policy, particularly in terms of the Senate's responsibility to grant or withhold its advice and consent to the appointment of officers. As Alexander Hamilton famously wrote in Federalist 76, this role of the Senate is crucial for the steady administration of the laws. So the executive brings energy, but the Senate must bring stability and security. The Senate has a key role, but for that very reason, it must marshal its resources very carefully. In light of those constitutional foundations, the current situation is very troubling. Too many offices require Senate advice and consent, at least relative to the Senate's capacity to carry out those duties with respect to all of those offices. There are too many vacancies for offices that the Constitution or Congress wanted to be filled with the Senate's advice and consent. And so I would be in favor, in general, of reducing the number of offices requiring Senate advice and consent, but precisely so that the Senate can be more effective in the remainder of its advice and consent role, to focus on the most important offices and hold them accountable for the rest of the agency's work. I want to emphasize the root cause of all this actually runs deeper, though. I think the root cause of much of this is the broad delegations of power that Congress has vested in agencies, great power, great discretion, and great responsibility, which makes each of these offices, the 1,200 offices we're referring to, all the more consequential. Indeed, it's no surprise that Congress would have wanted the Senate's advice and consent when it created these offices, given the powers that these offices are responsible for administering. So I hope the committee will keep in mind that the advice and consent issue we're discussing today is a problem, but it's a symptom of much deeper problems. And for that reason, I think that any reforms will have much broader ramifications. For example, if you reduce the number of offices requiring Senate advice and consent, the top-level agency offices will necessarily require and receive much more scrutiny, both from the public and also from the Senate. To the extent that offices are taken out of Senate advice and consent and removed all the way down to civil service, out of presidential appointment altogether, and of course there are constitutional questions surrounding any shift along those lines. But to the extent that offices are transferred out to civil service, that will only further exacerbate the debates we have right now about the state of our civil service and the political debates surrounding our civil servants. To the extent that the Senate concludes that it can carry out its oversight function less in terms of advice and consent and more in terms of Congress's power of the purse, of course that raises the deeper problems regarding Congress's appropriations, the appropriations process. And so I do hope that any reforms keep in mind the underlying problem of the powers, responsibility, and discretion wielded by these offices, and I hope that any reforms to the process are coupled, to the extent possible, with reforms to substance, the substantive powers of the agencies. I mentioned earlier Alexander Hamilton, the founding generation's greatest thinker on constitutional administration. When I think about these issues, I often return to a line he offered in Federalist 68. He said, "The true test of any constitution is its tendency and aptitude to produce good administration." That's pretty astonishing for all the things that Hamilton wrote about the Constitution, for him to say that the true test of our Constitution is the administration that it produces. That's amazing. In fact, he said it once in Federalist 68, and then he quotes himself later in 76 to make the point once again. In his time, administration was the true test of government. It remains so in our time, and I'm grateful for this committee for considering the importance of the issue and the need for reform.
Thank you, Mr. White. Ms. O'Connell and Ms. Simmons, according to the Washington Post political appointee tracker, an average of 4 in 10 Biden nominees have been waiting on Senate confirmation. This is not uncommon. Every recent president has experienced delays, but the delays just appear to be getting longer and longer. The time it takes for Congress to confirm presidential nominees has been growing during every single administration since President Ronald Reagan. You both mentioned several causes for delays when you presented your testimony to us. What do you believe, however, are the most significant reasons for these delays? And what actions from Congress should we consider to address them? And maybe give me a priority to, which you think is really significant that we should be thinking about. So we'll start with Ms. Simmons, and then Ms. O'Connell, if you would respond as well.
Thank you, Mr. Chairman. From the perspective of the partnership, the sheer volume makes it very challenging and contributes to just a greater bottleneck. So we would encourage fewer positions, as stated in my testimony. We think it would allow the Senate to focus on positions that most warrant your review and scrutiny, and it would make the best use of the Senate's time. We also think the process is extremely complicated as a result of the very challenging paperwork. And all of the paperwork serves a purpose, and it is meaningful with respect to adjudicating issues in someone's background, financial conflicts. But the questions that are asked are inconsistent, confusing, and it is very common for paperwork to go through multiple rounds and corrections because it's very difficult for nominees to get it right the first time. So there's a great amount of delay that occurs before the Senate even gets the nomination because there's so much involved in preparing the package that comes to the Senate. So we think simplifying the paperwork would also contribute to a more efficient and expedient process.
Thank you. Ms. O'Connell?
Thank you, Chairman. I think the two biggest reasons for these increasing delays on the Senate side, and there are delays on the White House side as well there. The first, I agree with Ms. Simmons from the partnership that just the sheer number of positions and the amount of time each position takes in terms of the vetting process has slowed it down. And so in terms of reform, I do think that the most important thing that Congress could do would be to cut the number of Senate confirmed positions. But I think what happens in its replacement is critical. So in the Streamlining Act enacted in 2012, those approximately 170 positions went from Senate confirmed to president alone. And there were delays, right, even when it's just the president alone. And so I think giving a lot of thought to which of those positions could be done by heads of departments to help speed up the process as well. The second greatest reason I believe for the delays has to do with changing norms in the Senate. And so in earlier administrations, I'm thinking President Reagan, President George Herbert Walker Bush, President Clinton, the norm was, especially in the first year, that agency nominees were confirmed by unanimous consent. And that, since President Clinton, doesn't happen anymore. And it's not because, in the end, the votes are close. So if you look at the recorded votes of President Biden's nominees through February 19th, over half of the recorded votes, there are more than 60 votes to confirm. But I think now a vote on an assistant secretary, and this is true both for Democrats and for Republicans, is a sign of party fealty. And so kind of the cooperative norms that existed don't exist in the same way. And so that is contributed as well. Now, in terms of reform there, I hesitate in terms of recommendations to changes in Senate rules, but to the extent that the Senate could establish some more cooperative norms, at least on a subset of critical nominations, say in the national security space, that would also be helpful.
Well, thank you. Thank you both for the answer. I'm going to ask you another question, both of you, and we'll start with you again, Ms. Simmons. Under the Appointments Clause of the Constitution, Congress has the right to determine which positions require Senate confirmation. So if we're going to reevaluate these positions that require the confirmation, would you please tell the committee what criteria or factors do you recommend that we consider if we go down this path? Ms. Simmons, if you'd start.
Sure, I'm happy to. Thank you for that question. And we strongly believe that every position should be evaluated by the Senate to determine whether it is a principal officer or an inferior officer. Titles themselves do not tell you a lot. There is a variety of responsibility assigned to different positions. Some assistant secretaries are Senate confirmed, some are not. But we recognize that there is a great opportunity to look at assistant secretaries and make a determination and perhaps start with the presumption that they do not need to be Senate confirmed. particularly if they are reporting to another appointee who's more senior, who is subject to Senate confirmation. That's a basic test of the Supreme Court, whether a position is under the supervision and direction of another Senate confirmed leader. And we think that is an important place to start, and obviously would support ensuring that you have the control and accountable officials that you need to do your jobs.
Thank you. Ms. O'Connell?
So functionally, we've already cut the number of Senate confirmed positions with the vast use of acting officials and delegations of authority. But the choice has been in the White House's hands in terms of where those acting officials and delegations take place. So I support strongly the Congress taking an affirmative role, and the place that I would look to first, the working group after the Streamlining Act enacted in 2012 pointed out that around 30% of still remaining Senate confirmed positions are part-time positions, requiring under 60 days of service in a calendar year. And I think those are positions, many of those positions where Senate confirmation could be cut. So in that push, the Senate did in mid-December to get a bunch of nominees through, we saw several confirmations to these part-time boards, to the Barry Goldwater Scholarship Foundation, the Corporation of National Service, and those seem like places to look, in addition to the suggestions laid out in the longer Partnership for Public Service report.
Well, thank you. Ranking Member Portman, recognized for your questions.
First, thanks to all three of you. You made some good suggestions. I still go back to the 2 points I raised in the opening. One is the point that this is not all about the Senate. Having been one of the associate counsels to the President for George H.W. Bush, who looked at nominees and their financial disclosure forms and so on, we thought it was pretty arduous at the time, but it's become much more so. The point you made today, I think, was that 30% of vacancies never receive a nomination. And we've talked a little about, Professor O'Connell just talked about acting officials and how that has increased. And in effect, actings have taken away the Senate role for confirmation. So anyway, I won't ask for more on that today, except to say that we would like, for the record, and maybe the partnership is the place to look to give us some more specific suggestions on the pre-Senate nomination process, the appointment process, and that's within the purview of this committee, so it's part of our oversight responsibilities. Second is just the quality of the candidates. We heard a lot today about making the process more efficient. Again, I think there's a lot of merit to that. But also, I get back to my point about improving the quality for nominees. Are there any changes to the Senate procedures, perhaps short of going back to a 60-vote margin, to incentivize that more qualified nominees be recruited and nominated? I open that up to all three of you.
Senator Portman, I'm happy to start and invite my fellow panelists to chime in. One of the things that we were surprised to discover as we began some of our work around presidential transitions and the high number of appointees that a new administration must confirm is how few positions are associated with position descriptions. We've actually created over 400 position descriptions that didn't exist and are not available. So in some cases, it would be helpful for the Senate to have a better understanding of what the real job is for some of these positions. And you articulated positions where you're very, very familiar with what's required, and the Senate has even put statutory qualifications in place. So we think a place to start is to consider whether there are adequate descriptions around the qualifications that you want in particular nominees for key roles in government, and making sure that there is an understanding, even among people who are being considered for those positions, as to what the job actually requires.
Mm-hmm. Mr. White, any thoughts on that?
Well, to your point about Senate procedures, I do think this is crucial. I understand there were strong arguments for reducing the threshold for confirmation in terms of cloture on nominees. But the fact is, the Senate's procedures have become, as the committee knows more than anybody, ever more sort of straight majority rule in more and more situations, with less and less deference given to the judgments and the the procedural powers of individual senators. And so we are seeing that filter through to the quality of the nominations. I think in general, the underlying problem here is that, and this goes beyond just appointments, but in general, administration is ever more identified exclusively with the president, not the president and the Senate. Administration is seen as something the executive takes care of while the Senate worries about other things. And so I think it's crucial for the Senate to reconsider its procedures surrounding advice and consent, to slow things down for the most important nominations and use them as real points of leverage for oversight of the agencies in general.
So fewer nominees, but those that are important, positions that are, from a policy perspective, most important, to spend more time on vetting those individuals and perhaps therefore improving the quality of those individuals.
Absolutely. And if I may, in terms of the criteria for removing offices out of the Senate advice and consent role, I think it is important to keep in mind each particular agency's substantive powers. Of course, the offices vary from agency to agency, but the agencies themselves vary in terms of their responsibilities overall. And so I would urge the Senate to be more cautious, or the Congress to be more cautious in removing the Senate advice and consent role for the agencies that have the most impact on day-to-day life. Of course, that's measured in a number of ways. OIRA, of course, keeps tallies of the costs and benefits of rules imposed by agencies. And so it might be worth keeping that in mind when you decide which offices and which agencies to remove from advice and consent.
Well, Professor O'Connell, you talked about this. You said that 30% of these jobs are part-time jobs, usually boards and commissions. And we talked earlier about 30% of the vacancies never receive a nomination at all. In other words, in effect, there may be some overlap there, but probably not much. 60% are either not nominated because an acting is chosen, so the administration never even nominates somebody, and another 30% are for part-time jobs. So in effect, it's a relatively smaller group, less than half, probably, that are actually getting attention that are substantive policy positions. Is that fair to say, Professor O'Connell, or have I missed my math there?
I'm not exactly sure that the 30% that don't receive a single nomination in the first 2 years from the research of Professor Lewis and Mark Richardson does not overlap considerably, as I understand it, with the part-time positions, because many of those part-time positions are ways of rewarding those who helped with the campaign. And so in that push in mid-December, 7, I think, of the nominees that were confirmed in the final week in December kind of came from those boards, whereas like assistant secretaries were still sitting. But I do think, right, you could remove some of these part-time positions, of course, within the confines of the Appointments Clause. The Senate could really focus on these key policy positions, which also have constitutional implications, as Mr. White has explained. And so that would be important. I would just say one thing back to your question on qualifications is, I guess I do think that many of agency officials who are put up by the president, confirmed by the Senate, and even those that present some hurdles are extraordinarily well qualified, and they are undergoing considerable sacrifices to serve our government. I do think by reducing some of the vetting and the forms, not to weed, of course we want to have qualified people, but what we have now is an insider game. Just the percentage of people coming from the DC area is quite high, and there are well-qualified people, as you know, from states other than Maryland, Virginia, and DC, and some of the changes could help expand the pool to get more diverse voices into the federal government.
Yeah, I couldn't agree with you more, and particularly with regard to Ohio. Thank you. But seriously, I mean, again, I've gone through 2 of these confirmations, but I will say, prior to 2013, when there was a 60-vote margin required, I think the quality of the candidates was better. I just think that. And I think some of these people that we end up passing with a strict party line vote would never have been nominated had there been a 60-vote margin. Same is possibly true with regard to our judges, because let's face it, it would require more bipartisanship. Now, the counter to that would be that the Senate has become more partisan, which I think is also true. But I must say, I think the quality of nominees since 2013 has changed. And again, I don't think some of these nominees that are now being nominated, who again have been online, I guess weren't many people worried about what Twitter was saying back in 2013. But some things they've said and done, and then the positions they're being put up for, like we talked about the Merit Systems Protection Board, someone who's openly and overtly partisan, it just doesn't make sense. There's got to be, of the hundreds of millions of people in America, someone else who can step forward, maybe from outside the D.C. Bubble, who is qualified for those kind of positions. So anyway, I don't disagree that the process is too arduous, and ultimately what we want to do is attract the best people to government. And yet I do think that the reality is that the quality of the candidates matter, and also that the Senate does have an important role of advice and consent, and we have to figure out how to make that work for those important positions that really matter. So with that, Mr. Chair, I'll turn it back to you. And again, I thank our witnesses very much and look forward, if you could, from the partnership, Christine, following up with some more specific recommendations for us. Thank you.
Happy to. Thank you.
Thank you, Ranking Member Portman. Ms. O'Connell, you studied the impact of vacancies in political positions, including adverse effects from having many positions without confirmed officials for prolonged periods of time. And obviously vacancies always occur for many reasons, but regardless of the reason, could you explain to the committee the actual impact these vacancies have on agencies?
Thank you, Chairman. I think that vacancies, particularly if they are lengthy and frequent, have several detrimental consequences. So the first is regard to performance. So sometimes agencies can't act. So although the Federal Vacancies Reform Act of 1998 gives long service for acting officials, that act applies only to cabinet departments and single-headed executive agencies for the most part, which means that independent regulatory commissions and boards like the Merit Systems Protection Board don't have recourse to acting officials. So for those agencies, and for those agencies who can't use acting officials and who have quorum requirements, then you have real effects. You get the 3,600 case backlog at the MSPB, for example. Even in agencies which are able to use acting officials, performance is also impacted because acting officials are hesitant to take on big new projects because they perceive themselves generally as caretakers. And so rulemaking, for example, in the first year of federal agencies is lower in other years as agencies staff up. And of course, rulemaking can be both regulatory and deregulatory. A second consequence of longer vacancies has to do with employee morale. So the Partnership of Public Service has run various surveys of agency employees, and they have found a connection between agencies who lack Senate confirmed leaders with what they call static or declining employee engagement. So employees seem to be less happy at agencies who don't have confirmed leaders. And then a third consequence is that in the agencies that can use acting officials, there are detrimental consequences to long use of acting officials, and when those time limits run out to the delegations of authority. In addition to undermining the Senate's role, there are some legal questions that arise, and so I think that there are often many detrimental consequences.
Senator Rosen, you are recognized for your questions.
Well, thank you, Chair Peters, and of course, I see Ranking Member Portman there, and I want to thank the witnesses for their insights today. All of this is critical, and I'm worried about our critical services for veterans. So, Ms. Simmons, in your testimony, you referenced the VA's Undersecretary for Health, a position that has not had a Senate-confirmed leader since 2017. This position leads the Veterans Health Administration, which is the country's largest integrated health system. It serves 9 million enrolled veterans each and every year with more than 1,200 sites and an annual budget of $61 billion. Nevada is home to over 225,000 veterans, so I'm deeply concerned that the VA had to stand up a commission last year just to identify candidates to lead and manage the VHA. So, Ms. Simmons, what can Congress do to ensure that positions like these that aren't as high as cabinet level, but still oversee critically important government services, including for our veterans, that they just don't go without permanent leaders for years at a time? This really hurts our country.
Thank you, Senator, for that question. And we are very much in favor of trying to find creative ways to fill these positions that are truly management in nature and require high levels of professional and technical expertise and are really apolitical. And I think service to our veterans is certainly a place where we can do more to think about how to provide continuity of leadership and to just think about the positions differently. So one idea is to change the norm or think differently about whether these positions actually turn over with the change in administrations. Inspectors general are positions that are Senate confirmed, but by tradition, they're not expected to turn over when a new administration comes in. So there's a potential to think differently about some of these management jobs and adopt that same kind of norm or tradition of not having them turn over. Another suggestion would be to think about providing a set term, a longer term with professional qualifications so that you have greater assurance that someone stepping into the role would understand that they had a runway that went beyond one administration and that they were there for their professional expertise, and you could even build performance measures around that position. Another thing we think is important is to think about having performance plans for political appointees. This is something I think would speak to Senator Portman's concern about the quality of nominees. We strongly feel that people in these important positions need to be qualified leaders. They should be developed and trained as leaders. They should be held accountable for their performance, and being clear what good performance looks like and setting some terms and extended terms would allow them to have more continuity in some of these key positions, especially in areas as apolitical and important as service to our veterans.
Well, that's great. I think we also have to be sure that we identify how we identify those quality candidates, get them into the pipeline. Implementing some of the things you're thinking of and others is a good thing. I'd also like to talk a little bit about regional appointments, because last week, President Biden announced 13 regional appointments for FEMA, the EPA, the Department of Agriculture, including the Nevada State Executive Director for the Farm Service Agency. The nominee, Janice Colvett, well, she has experience as a career federal employee working on federal farm programs as a cattle rancher in Elko, Nevada. She's a Nevadan. And so regional appointments like these are just so important, especially in Western states where the local economy, industry, and climate challenges are not always familiar to federal government workers here in Washington, D.C. So again, Ms. Simmons, I understand these regional appointments aren't subject to Senate confirmation. So why is it that it can take so long to fill these critical roles in a new administration? And what effect does the Senate confirmation process in general have on these appointments, even when it's not required for a particular position?
Thank you for that question. And this speaks to something that Professor O'Connell raised, which is the value of reaching outside of Washington for candidates and filling these important positions with people who bring diverse perspectives from around the country and can really bring their personal expertise and experience to bear in service to the public. When there are so many positions subject to Senate confirmation, it's almost essential that a very small Office of Presidential Personnel devotes their attention there. And that tends to take up a lot of the time that could be spent sourcing candidates for some of these more regional positions not subject to Senate confirmation. It's also true sometimes that some of these regional positions or other positions that are not Senate confirmed are not filled until the Senate confirmed position is filled above it. So that can also contribute. And finally, I don't have specific knowledge of this situation at USDA, But when Congress is operating under, when the government's operating under a continuing resolution, there also might be financial reasons why they're not able to fill particular positions that they need to fill until full year appropriations are passed. So those are just a few of the comments, and I would invite my other panelists to chime in.
Yeah, because it's really, government services really suffer in our regional areas when these positions aren't filled. Professor O'Connell, would you like to comment on this as well, please?
Thank you, Senator. I agree with Ms. Simmons from the partnership about the various reasons. I would just add with regard to the Presidential Personnel Office, is that we've seen a lot of turnover in PPO across Democratic and Republican administrations. In President Obama's administration, for example, the head of PPO, while trying to fill all these plum jobs across federal agencies, decided that he wanted to take a plum job as ambassador to South Africa, and so was gone from the Presidential Personnel Office within 6 months of the start of that administration. And for President Biden, the first director of presidential personnel has also left. So I think it's also important for Republicans and Democrats, and there was turnover in PPO as well in the Trump administration, to have experienced people in presidential personnel, to have the staff, and then have the various computer systems, the online systems, to help process more quickly people both for Senate confirmed positions and then for these other political jobs.
Thank you. I appreciate that. I see my time's expired. I just think we really have to also address the Federal Vacancies Reform Act, its relationship to specific agency-specific succession schemes. We have a lot to do here. People need services, and I appreciate everyone for being here. Thank you, Mr. Chair.
Well, thank you, Senator Rosen. Ms. Simmons, the Partnership for Public Services unconfirmed report states that there are both economic and performance costs related to the current number of appointments and the pace at which they assume that office. So could you elaborate for this committee on what those economic and performance costs are and how they specifically relate to the effectiveness of our agencies?
I'm happy to, Mr. Chairman, and it really speaks to the importance of government operating at its very best, particularly given the many challenges that our government is facing and the need to serve the American people as effectively and efficiently as possible. We know that having vacancies in critical positions contributes to delayed decision-making. Many acting officials are toggling between two jobs, which means they are often not able to fully commit to either position and to give it as much attention as it may require, and that could de-optimize the effectiveness of agencies. We know that legal challenges are possible when people are serving in acting roles, and it's questionable in terms of how they stepped into those roles. We also think that there is national security implications for positions that are not filled, and this is something that the 9/11 Commission recognized as well. I'll also note that there have been bills introduced in the past that had a variety of different cost estimates associated with the savings that would be realized from reducing the number of positions subject to Senate confirmation, even going back as a bill that Senator McCain had introduced, capping the number of Senate-confirmed positions, and it had a very high estimate of the amount of money that would save.
So I'll ask another question for you, Ms. Simmons, as well as Ms. O'Connell. The Federal Vacancies Reform Act of 1998 allows the President to fill vacant positions requiring Senate confirmation with an acting officer. But the acting officer may serve for a 300-day period at the beginning of the administration and a 210-day period later on in the administration while the President decides who they will nominate. So if each of you could briefly share with this committee what happens when the time period runs out and the impact that this has on the agency and on congressional oversight. Ms. Simmons?
Well, thank you for that question. And what happens when that time period runs out is often not transparent to Congress or to the public. We did some research on this and found a variety of titles that were put in place. At times it appears a position has been unfilled altogether. Other people will fill it with titles of principal official performing the duties of. There are deputies that step in. So it is a really patchwork of ways in which administrations respond. But the fact is that the work needs to get done. And so this is why we're encouraging a fresh look at the Vacancies Act to try to fix some of the ambiguities in the law. One of the things we strongly recommend is to allow someone who has been nominated to also serve as the acting leader of that agency. And this is something that Professor O'Connell also mentioned in her statement. We think that there are opportunities to fix some of the places where the act is unclear. We think more timely reporting is also essential. There's a requirement now that agencies report to the General Accounting Office when there is a vacancy. It's very spotty and very slow. So again, there is not much transparency as it exists today.
Thank you. Ms. O'Connell?
So the time limits for the Vacancies Act are long, Chairman. So you get in the first year 300 days. If there's a nomination, all throughout the nomination, if that nomination is returned, an additional 210 days. You get the time for a second nomination. If that nomination is returned or withdrawn, a final 210 days. So it's possible under the Vacancies Act to have over 2 years of acting service. Now, what typically happens is we don't see those pending nominations. So after the 300-day mark, the acting title is gone from those leadership pages, and instead we typically have delegations of authority. So under current case law, functions that are not exclusive to the vacant position are delegated down. Mr. Berry from the Cato Institute, I believe, has submitted a written statement talking more about some of the legal issues. He and I disagree about kind of what to do in some regard to that. But basically, then you have senior officials performing the duties and functions of the vacant office occurring when the time limits run out. And as Ms. Simmons indicated, there are transparency problems. Although you have reporting under the Vacancies Act for acting service, there are no reporting requirements with regard to delegations. It's incredibly hard to find information about delegations. I was a consultant to ACUS on a project on acting officials and delegations of authority. It was very hard to track down not just acting officials, but then when the time limits ran out, what was happening with regard to those vacant positions. Now, it's a tricky balance because you want transparency, you want accountability, you want the Senate's role, but you also want government agencies to function. And we have a dysfunctional appointments process. And so somehow we need acting officials and delegations of authority for the stopgaps, but we need to reduce the time of those stopgaps.
Well, thank you. Ranking Member Portman, recognized for a question.
Well, thank you. Thank all three of you. Great point about acting. And we also talked earlier about career because I think, Mr. White, in your testimony, you say that if some Senate-confirmed positions are converted to career roles, then the federal civil service should be reformed also. Senator Langford's here, and I want to turn to him now to make sure he has a chance to ask his questions. But if you could just, for the record, provide us some specifics on that, that'd be very helpful in terms of should we choose to have more career roles, what kind of reforms to the civil service might be appropriate. Thank you, Mr. Chairman.
Thank you for your question. I want to be very clear at the outset, the Constitution places limits on which offices could be removed outside of the political appointments altogether and returned down to civil service. Setting that aside, in my testimony, when I referred to the connection between the appointments issue and the civil service issue, I was just referring to the broader debates that we've been having in Washington and beyond for years now over the state of our civil service, the political criticism of it, some of it well-founded, some of it not at all well-founded, and questions about the policymaking discretion that is in the hands of some civil servants who have less accountability to the agency heads or to the president. And so in my testimony, I was merely pointing out that to the extent that more agency authority is taken out of presidential or Senate-confirmed appointments and moved down into the civil service, it will only ratchet up the temperature surrounding debates on whether and how to reform civil service.
Yeah. That's why I asked the question again. If you could provide some more for the record, that'd be great. But if we were to go down that track, as an example, reduce the number of confirmed positions, have more of them be career, it might be an opportunity to make some long-awaited changes in the civil service as well. And that's why I was interested in your response. Thank you, Mr. Chairman.
Thank you, Ranking Member. Senator Langford, you're recognized for your question.
Mr. Chairman, thank you. Thanks for all the input on this. This is one of those things that most folks outside of D.C. are not going to pay attention to at all, but is extremely important for the functioning of not only the Senate, but of the administration in trying to be able to get right people in the right place. So I appreciate all of you spending so much time helping us think through some of these issues and to be able to talk about it. I do want to talk about some different things on this. One of them is for individuals that are going through the presidential nomination process, they have to divest from their business. They have to divest from their stocks and all kinds of things they have to walk away from. And then they spend a year or 2 or 3 awaiting the confirmation process on this. Well, that definitely encourages people not to take these jobs. And we create a discouragement from people to say, I would do that job, but it may take 2 years to go through it. And I'm not going to do 2 years without my business, without income, and have to be able to sell my business and then not even be certain if the Senate's going to even take up my nomination at all. That's a terrible process. How do we get good people to be able to step into these roles when there's so much uncertainty at the beginning? So what would your suggestions be on how we handle personal finances of individuals while they're going through the process? Would it be a recommendation to say they have to divest from all those different investments if they take the role and are actually confirmed, or do they have to take it while they're going through the nomination process?
Senator, thank you for that question. I'm happy to start, and I invite my fellow panelists to chime in. I am not an expert on the Ethics in Government Act, which governs the financial disclosure process. But I will share that what we hear from nominees and from transition teams and from people on Capitol Hill working on these issues is that as the financial products have become so much more sophisticated, that the act hasn't really kept up. And so there are so many challenges nominees face in understanding how different things they own will be treated and viewed. And it often will be months into the process before they are told that a particular managed account is not a mutual fund or not treated the same way and needs to be disposed of or mitigated in a different way. And it can be very challenging. So bringing additional clarity or as early as possible will help people complete their forms and do so in an accurate way. But we also think it's important for people to understand what these jobs require, what public service requires. It is a different place. There's the responsibility of public trust, and people need to have a clear understanding of the both the privilege of serving in a presidentially appointed role and also the sacrifices that go with it before they say yes.
Yeah, there's a different set of sacrifices, though, to be able to say to someone, I'm going to need you to sell your business, walk away from all your investments, and live isolated financially for the next year and a half before we'll give you an answer if you're going to get this job. Right. I mean, that's not right. Again, if they take the job on, that's different than you've got to sacrifice all this stuff, and then we'll tell you later whether you're actually going to get it or not. Mm-hmm. That's what I'm driving at. I have no problem with maintaining ethics for individuals that are serving in government, but we're talking about those that are literally in the application process at that point, that the Senate is still considering advice and consent on that. That's a whole different issue for me. And so I do think it's an area that we've got to be able to address. There's been some conversation about reducing the list. And I fully take on the responsibility of constitutional and trying to be able to deal with advice and consent on this. But there are some roles that are out there. For instance, the legislative affairs person for several of these agencies. Why are we doing Senate confirmation for someone that the agency is picking to be in relationship with us? So that seems nonsensical. Now, I'm not asking for a full list of it, but if you go through different positions like that, like the legislative affairs individuals and others that are out there, we're at 1,200 some odd at this point now that are going through the process. The number, I'm not trying to get to a magic number. I'm trying to look at, as you look through the list, do any of the three of you see a number to say, this is more reasonable based on some of these positions that may not need the same kind of Senate oversight on it? Is it 800? Is it 900? Is it 1,150? So, Adam, you want to take that on?
Yes, although I must admit I don't have a number for
Yeah, I'm not looking for a magic number. I'm just trying to get a guess.
having highlighted the example of the Office of Legislative Affairs and other agency offices that don't have significant policymaking authority and are primarily either ministerial activities on behalf of the agency head or fact-finding, 25%.
Yeah, be a decent guess. Simmons, you want to take a guess at that?
I will. There are 137 approximately Senate-confirmed assistant secretary positions. We would recommend starting with the presumption that those do not need to be Senate-confirmed unless the Senate affirmatively decides they need to be because of the responsibilities of the job. Right there, if you just take the legislative affairs positions, you've got over a dozen that you would take off the rolls of Senate-confirmed. And then Professor O'Connell has spoken also about part-time boards and commissions. There are dozens of them that are advisory in nature and we think could easily, without detriment to the mission, be converted.
Mr. Connell, you want to be able to add into that as well?
Thank you, Senator. I think the number is below 1,000. Of course, what is desirable is not always politically feasible, and I would start with the part-time boards. And Senator, if I could just quickly go back to your paperwork question and financial conflicts of interest, I do think there is a difference between the nomination phase and what happens once someone joins the government. And we need to spend more time thinking about what happens in that initial phase and how that may discourage people from entering government service. And I do think there's some that could be done with streamlining that financial paperwork, as that working group in 2012 indicated some of their recommendations are targeted toward financial disclosure.
Right. Going through the presidential process, the nomination process, is the equivalent of a full-body cavity search through everything in your life and everything in your history and everything in your finances. It's a brutal process for individuals to be able to go through. So people need to know, if you're going to step into this responsibility, there's a lot of background that we're going to look at for those individuals, rightfully so. But then to discourage them from even taking it on, or to have to live without an income while they go through the process is a very different issue on this. One last question that I had on this, if you don't mind, Mr. Chairman, can I ask one last one on this? I know right at time. And that is the issue of how do we incentivize the administration to nominate people? We've had multiple administrations in a row that have not nominated, for instance, IGs, and they just won't put someone up. That's a problem. Not only do we need to have good oversight of it, but we need administrations to actually nominate individuals to these roles. We have several roles that there was literally never a nomination for it. What would you suggest as far as leverage or engagement to be able to actually make sure we do get nominees for areas where we need nominees? Mr. White.
Senator, I guess I could take that on. I mean, right now, as you know, 3 of the 15 cabinet departments do not have a confirmed inspector general. 2 of those 3 do not even have a nominee. The number was even greater in August of 2020, where I believe 7 cabinet departments lacked a nominee for IG positions. So what can be done? So I think these positions where they're either done without regard to partisanship, that's also true for the Undersecretary of Health that we've talked about, Ms. Simmons talked about in the Veterans Administration, is those positions are harder to fill. I think that White Houses turn to the more political positions first. And so I think that the Council on IGs, with regard to recommendations, pressure being placed on the White House, and then cabining who gets to serve as an acting IG, so we don't have some of what we saw in the Trump administration with the firing of IGs and then having acting IGs who are not drawn from other confirmed IGs or from IG staff, but instead are political appointees. And whether you're on the left or the right, Congress needs IGs who either confirmed or acting, who are nonpartisan, doing critical oversight work.
Yeah, just to be able to keep this nonpartisan as well, the Obama administration in 8 years had several IG positions they just refused to ever nominate someone for, and they just didn't want the oversight in that area. So this is a nonpartisan issue, but we do have to have important individuals in that spot. Mr. White, you were about to say something.
If I may, the bluntest tool for creating incentives for agencies to nominate and fill these positions would be to tie it to the effectiveness of their substantive regulations. So any agency with policymaking power that they try to effectuate through rulemaking any rules effectiveness could be tied to the filling of those offices, require the agency to have the full complement of Senate-confirmed offices in place before any new regulations could go into effect. That would certainly create an incentive for the agency to act.
Okay, thank you. Mr. Chairman, thank you.
Thank you, Senator Langford. Senator Carper, you are recognized for your questions.
Thanks very much, Mr. Chairman. I want to thank our witnesses. I want to thank Dr. O'Connell. I want to thank Christine Simmons. I want to thank Adam White for taking the time to be with us today and share your thoughts and respond to our questions. Mr. Chairman, and to our witnesses and our colleagues, I'm getting some flashbacks here. I'm thinking of 10 years ago when another senator from Oklahoma, in that case, Tom Coburn, and I were privileged to lead this committee. And we focused a whole lot of time and attention on trying to make sure that a different administration was able to not only nominate people to serve in leadership positions, especially in Homeland Security, but we could actually get them confirmed in a bipartisan way. And this is really important stuff. And I'm grateful for that we're doing it. And grateful to our witnesses for your help. I have really three questions. One would be deal with the need for Senate confirmed leadership at federal agencies. Another would be the Plum Act, something like bipartisan legislation that I've been privileged to have some role in crafting. And third is lessons learned from previous administrations' use of acting officials and delegation of authority. The first question, though, is on the need for Senate confirmed leadership at federal agencies. This is a question for all of our witnesses. And again, when I alluding to the time several years ago when Senator Coburn and I were held a number of hearings that very much remind me of what we're doing and talking about today. And we invited witnesses from the Department of Homeland Security to come and talk about Swiss cheese. Not the kind we eat, though. Rather, we're discussing the high number of vacancies or acting individuals who are serving in top leadership positions at that time, and in the Department of Homeland Security. And it reminded me and reminded us then of, reminds me today of Swiss cheese. I'm concerned, let me just say, as recovering governor, I know how important it was to be able to get my team in place. We have a tradition in Delaware, a highly bipartisan tradition, that the governors, for the most part, are given the opportunity to put their teams together. And we seem to have gotten away from that here. And it's a matter of concern it's been a matter of concern for me for a long time. I don't care who's the president. But we have a similar situation today atop several of federal agencies and how it impacts agencies' abilities to deliver results for everyday Americans. Question for all three of you, if I could, Professor O'Connell, Ms. Simmons, Director White. Could each of you please maybe take a minute to discuss how a lack of Senate-confirmed leadership and long-standing vacancies at top federal agencies affect workforce morale and the ability of agencies to execute their missions and deliver results for the public? Professor O'Connell, you want to lead us off, please, and then Ms. Simmons, and then Director White.
Thank you, Senator. So as you indicate, there are detrimental consequences, and very briefly, there are two sets of them. The first set, as you know, are performance related, and given your experience with the Department of Homeland Security and this committee, in particular with regard to Homeland Security, vacancies are a problem, and they've been a problem in administrations since the department was created and got into business in 2003. So both in Republican and Democratic administrations, there have been vacancies in DHS that have hurt this country. The second bucket of consequences has to do with accountability, and the Senate's role is when we have vacancies, we typically do have acting officials in the Department of Homeland Security, but they are less accountable. And sometimes in the last administration, they generated litigation with regard to their service, and some of their actions ended up being struck down because of improper use of the succession provisions in the Homeland Security Act.
Good, thank you. Thanks, Professor. Ms. Simmons, please, same question.
I agree with what Professor O'Connell offered, and I would just say, at the end of the day, having Senate-confirmed leaders in place promotes more efficient and effective administration because decision-making is clear. the accountability of those people to the Senate is greater and to the Congress is greater. And the employees that are working in the departments and agencies understand who they're getting their marching orders from and can execute on the agenda. So we think it is in the best interest of government to have Senate-confirmed leaders in place.
But government and the people, I would say, yeah. Okay, Director, same question, please. Thank you.
Well, thank you. In addition to all that's been said, I'd say that Senate confirmation has an important role to play in the quality of the leadership and management of the agency. A president will nominate, an administration will choose an agency official for a number of reasons. Often their alignment with the policies of the administration. And of course, those are all important for energetic execution. But the quality of leadership and day-to-day management is also important. And so is the character of the nominee, his or her sense of the mission of the agency, and also the legal constraints upon the agency. Those are all considerations that transcend any one administration. And it's important for the Senate to be an outside check on the instincts of any single administration to ensure that the agency over time from administration to administration is well managed, confidence-inspiring, and restrained by the rule of law.
All right, thanks, Director White. I have another question I'm going to ask Professor O'Connell and Ms. Simmons to respond to here, and then I'm going to have questions for the record for a couple of you as well. But here's the question for Professor O'Connell and Ms. Simmons. Both of you mentioned your support for the legislation. It's called Periodically Listed Update to Management, also known as the Plum Act of 2022, bipartisan bill championed in the Senate by Senator Braun, Senator Merkley, and myself. Well, this legislation promotes a more transparent and accountable executive branch by requiring the Office of Personnel Management to modernize our government publication. It's known as a Plum Book, which is published every 4 years, serves as a comprehensive directory of information for senior policy and management roles in the executive branch. Professor O'Connell and Ms. Simmons, how would passing the Plum Act help tackle the issue of longstanding federal vacancies and ensure that political appointees are well qualified for the positions to which they've been nominated? Please proceed. Professor O'Connell and then Ms. Simmons, and then I'll be quiet. Thank you.
Thank you, Senator. Actually, at the very end of this set of books, at the very end are some Plum volumes. So I have hard copies of the Plum book. So I strongly endorse and am so grateful for your work on the Plum Act. Support it for various reasons. One is a transparency mandate. It's hard to figure out who is serving in a critical Senate confirmed position, and the Plum Book includes beyond Senate confirmed positions, other political appointees, as well as positions which are carried out by senior career workers in federal agencies. And it's important to know who's doing that work, or if that work is not getting done. And the Plum Act would, in addition to the hard volume, which I keep in my office, would also continually update that information electronically, and that is important. Second, with regard to staffing these positions, the Plum Act would make clear which positions have which appointment structure, fall into which agency, and along with good government organizations like the partnership developing job descriptions, can help potential nominees, help the Presidential Personnel Office in terms of staffing them. So I hope that Congress will enact the Plum Act very soon.
Yeah, Professor, thank you so much for those words. Ms. Simmons, just briefly, same question.
Thank you, Senator. To echo that, first of all, having the Plum Act enacted would allow for a much more efficient process. It would ensure that the Plum book can be updated in real time. Right now, it's a snapshot every 4 years, and there's no possibility to correct errors. The most recent Plum book was published not till December 30th, so well after the presidential election, and it was missing in the index 7 agencies, and there was no way to go back and correct that. So we think that making it more accessible, more transparent, providing better accuracy and more efficiency would be very good for transparency and good for government and the people it serves.
Thank you so much. Thank you both very, very much for that. And to our chair, if I can just ask a question. I'm not going to ask for the response right now, but Professor O'Connell, one last question for the record. And when is it appropriate for the administration to use acting officials and delegations of authority? What are some lessons learned from previous administrations' use of these temporary measures that Congress should keep in mind as we consider proposals to reform current Senate confirmation process and existing federal vacancy law? Again, Professor O'Connell, if you'll respond to that, it's for the record. I'd be most grateful. Thank you all for your testimony today. This is something that's near and dear to my heart, and I think it's important, very important for thank you.
Well, thank you. Thank you, Senator Carper. Senator Hawley, you're recognized for your questions.
Thank you very much, Mr. Chairman. Thanks to all the witnesses for being here. Great to see each of you. Professor O'Connell, if I could just begin with you. I know that this is your field, and I'm interested in getting your perspective on some of this, particularly some of your historical perspective. Let me just begin, though, with something that you mentioned, I think, in your testimony, and that is that in some sense the problem of vacancies begins with the executive branch. President Trump, for instance, if I've got my numbers right, he didn't nominate a single individual for 36% of posts. I mean, that's a lot. That's a big number. President Obama, similarly, did not nominate a single individual for over 25% of posts during a similar time frame. That's also a pretty big number. What do you think we should infer from that?
I think you could, Senator, thank you for that question. I think you could infer several things. First, that there are a lot of positions to fill, and some positions take priority and others do not. And so sort of in the fixed resources, fixed time, some positions just don't take a high priority. Second, I think you can take that there's not a lot of pressure to fill those positions, right? So as you indicate, Senator, and I'm quoting here from research by David Lewis and Mark Richardson out of Vanderbilt University, 30% of positions on average don't receive a single nominee in the first 2 years, looking at the past 3 completed administrations. And I think a large part of that is the Federal Vacancies Reform Act of 1998. So at least for a set of positions where you can have acting officials, the need for a Senate confirmed person in that position, just is not as great, because you can have an acting official carrying out all the duties, exclusive and non-exclusive, to that Senate confirmed job. And then when the time limits run out, and they are very generous time limits, what happens in these agencies is you have delegations of authority downward for the non-exclusive functions. And basically, most of the functions are non-exclusive in federal agencies. And then you have delegations. So you have at the Department of Homeland Security across Democratic and Republican administrations. You go to that leadership page and you look right now at the undersecretaries. The majority of them are not Senate confirmed officials, and you have senior officials performing the duties. And under these delegations, there are no time limits under the Vacancies Act. And so you can have those positions carried out for years, for entire presidential terms, without ever putting forward a nominee.
That's very interesting. Do you think is one of the takeaways here that maybe the federal administrative apparatus has become so gargantuan that even the person who has some directive authority of it, speaking of the president, but it's only some directive authority, but even that person doesn't seem to have an enormous incentive to fill. Even he or she does not necessarily see the need to fill the entire apparatus of an administrative branch that they don't control it, of course, but they largely direct, or could. And yet they think that they can administer the government without, in President Obama's case, a quarter of positions. In President Trump's case, 36%. I mean, what's your view on that? I mean, is part of the issue that the size and scope is just so gigantic that it's hard for even the president, who has a decided interest in this, it would be in their interest, but it's hard for even the president to find a pressing need to fill these positions, some of them.
So as the economy has changed, we have a large administrative state. I think I'm more a fan of the administrative state than you may be, Senator. But what's interesting is that from the 1960s, federal employment has been relatively constant. So it's not as if the federal government has expanded in size. Now, what has happened, research by Professor Paul Light, known as thickening of government, And so you have more of these management type of positions. We see this, I'm an academic, we see this in universities too, where you have a thickening of the management positions. And it's not clear that all of those management positions are needed. And in fact, to have greater presidential control, if you had fewer of those positions, like if the kind of line of accountability was clearer, might actually be more helpful in terms of the president's interests and constitutional role in managing federal agencies.
So that's interesting. Let me just ask you, and I'm probably going to date myself with this next remark, show you that I haven't, show you when I was in law school. But when I was in law school, Stephen Skowronek was someone in his work on the administrative state and as it related to the political branches and political energy. You know, he talked about the waning of political time in America because of, I think, the phenomenon of thickening that you just said. I mean, part of his, if I remember, and you could correct me if you know Skowronek, and apologies to him if I'm terribly misrepresenting his work. But my memory of it is that part of Skowronek's point is that as the administrative apparatus has become thicker, deeper, bigger. I mean, pick your adjective of choice. It has become more difficult for somewhat perhaps paradoxically, more difficult for presidents to enact their agendas. Of course, it's also more difficult for Congress to control these agencies. Do you agree with that analysis as I've stated it in rough outline, or do you think that's off in some fundamental way?
I think it has to be acknowledged that federal agencies are doing more complex work. When I was referring to thickening, I was referring to a different sort of thickening. I was referring to the thickening of leadership positions,
Right.
like the growth, for example, of assistant secretary positions. So we have that. Now, does that impact presidential control? That's less clear. I mean, I think what we've seen in recent administrations on the left and on the right is the rise of what now Justice Kagan labels a presidential administration. And we have that through increasing presidential directives, whether they're executive orders or presidential memoranda directing federal agencies to take various actions. And I think that is a counterweight and does allow presidential control. Of course, that raises certain concerns, both on the left and the right, about the president's role in terms of directing federal agencies. When we think about, of course, Congress's role in terms of what it delegates and what it wants from federal agencies.
Yeah, fair enough. My time is I was going to say it's just about expired. Technically, it has. But one more question, and I'll stop. I will ask this question, and I will cease and desist, Mr. Chairman. I just wanted to ask Mr. White, Dr. White, to be able to weigh in on this, just in terms of the administrative state. I mean, my own view is, I was previewing with Professor O'Connell, as part of what's happened here is that the administrative state has become so powerful, in the sense that this body, the Congress, delegates so much to the administrative state that. And there are now so many political positions to fill that even presidents don't find there being a great incentive to fill them all. I mean, just give us your perspective on this and what you think reforms might be. I mean, how might we go about thinning this out in a way that is constitutionally responsible?
Well, I agree completely with the point. And in my written testimony and in my statements earlier, I tried to return time and time again to the basic problem of delegation, the problem of overbroad delegation exacerbating the issues we're discussing. And your point about slower and slower execution is right on point. In our system, Congress ought to take its time legislating, and then once it's made a decision, it should make a decision that the president and his administration can quickly and clearly execute. That's the energy in execution. Today, unfortunately, with so much power and discretion delegated to the administration, you have the worst of both worlds. It takes forever for an administration to formulate the policy and then go into execution. So we often think of delegation as empowering a president. It does in a way, but in terms of actual execution, it really deforms execution and slows it down. So anything that can be done to reduce the breadth of discretion and powers delegated to the agency will make execution faster. It will take the temperature down on Senate confirmation fights, and will alleviate a number of other sort of secondary symptoms of the delegation problem that we're grappling with here today and in other issues before the committee.
Thank you, Senator Hawley. I'd like to take this time just to thank thank our witnesses for joining us today for this very important discussion, a discussion that I intend to continue to follow through for. We're hoping to draft legislation out of this committee to deal with some of these issues, but we want to make sure we have a robust discussion among members of the committee as well as experts like each and every one of you. And I appreciate your time here today. Effective government clearly depends on a reliable and a consistent process for filling senior roles, and vacancies in these roles lead not only to significant operational and managerial risk, but they can also compromise our national security. And while the Senate must certainly continue to exercise our constitutional authority and thoroughly consider nominees' qualifications, I remain confident we can better streamline the presidential appointment process to help fill these critical positions all across the federal government. I want to thank my ranking member, Portman, for holding this hearing with me here today, and I certainly look forward to working with him and others on the committee to address this issue in the future. The record for this hearing will remain open for 15 days until 5 p.m. on March 18th, 2022 for the submission of statements and questions for the record. Again, thank you for your appearance here today. The hearing is now adjourned.